I'm Cynthia Rowland, and this is episode 113 of EO Radio Show. In today's episode, I talk with Ben Buchwalter about a hot topic for nonprofits with employees, the surge in return to office mandates. Ben specializes in working with employers to manage and mitigate employment law risks to achieve their goals. He has deep experience defending companies in single plaintiff and class and representative action lawsuits related to discrimination, retaliation, harassment, leaves of absence, wage and hour compliance, and requests for accommodations. Through his experience defending companies of all types and sizes in litigation and as an in-house employment attorney, Ben always strives to understand what is most important to his clients in order to reach the best company-tailored resolution of disputes. We're lucky to listen in with Ben today. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. I'm delighted to be joined today by Ben Buchwalter. In working with Ben to support our charitable clients, I've found him to be passionate about advising employers on pragmatic and proactive employment programs to help the California employers see around the corner and establish measures tailored to their goals and their culture to minimize unacceptable risks. When employment disputes arise, Ben offers an experienced and steady hand toward resolving conflicts. And when necessary, he can vigorously defend his clients in federal and state courts and arbitrations and before administrative agencies. Thanks for joining me today, Ben.
Thanks, Cynthia. Glad to be here.
Before we get into the nitty-gritty of this hot topic, tell us a little bit about yourself. What inspired you to be an employment lawyer? Is this, something that came from a prior career? How did you get here?
Sure. So I'm most interested in how the law impacts people in their day-to-day lives. And I think employment law is such an interesting way to see that because we all work, we all deal with tricky situations at work. And I love being part of that. I love helping people at companies figure out how to address these tricky situations that come up between people at work.
So that's certainly true. We all are either employed by or employ other people. And so it touches, like you said, everybody. And every employer is a little bit different. We can do a broad brush, but the cultures are always a little bit different. So let's start by talking generally about some of these practical considerations and also the general framework of the laws that apply to the employer and in the employment context. What's the best way to start into this conversation?
Sure. So one thing that I've noticed across employers that I've worked with when dealing with return to the office considerations is that there's a need to balance the need to be efficient in the completion of their work while also caring for employee well-being. I find that that's especially important for the nonprofit organizations that I work with, who tend to be especially conscious of how employees are feeling, how they're doing in their day-to-day. And so that's one of the reasons I think it's so important to get this right. Absolutely.
I couldn't agree more. So how do employers start figuring out this new, it was bad enough that we went into the COVID era. Now we have to come out of it. What are you saying there?
Exactly. And I think that's one of the key challenges is that we all got comfortable working from home. We all started to use Zoom. We all started to communicate by email. And there can be a little bit of discomfort coming back to the office where people are starting to realize sometimes I don't enjoy being around certain colleagues or the commute is really challenging. Or one thing that is disproportionately felt among people of color is that, maybe they don't get treated the way they would like in the office. You often hear about certain microaggressions that come from their colleagues. And coming back to the office can bring all of those issues into the fore, which leads to the main concern that I've seen across my clients, both nonprofit and otherwise, say that, okay, we've implemented these return to the office policies, but the challenge we're seeing is that people are resigning and we're losing key talent. Or even if we're not losing key talent, maybe they're becoming less engaged. What I think a couple years ago was commonly called quiet quitting is becoming just as prevalent or even more so as people are coming back to the office.
Yes. And I have seen for the mandatory attendance, obviously some employees don't show up at all. Others come into the office and nobody else is there. And so there's a morale hit. They're like, why did I just slog through the rain and the storm? And then sometimes they come in, log in, drink a cup of coffee and go home. And that counts. I mean, what's the point of that? So it's a really tricky time, I think.
Exact. That's become known as coffee badging, where you come into the office for an hour just so it'll show up on your statistics, but you're not actually in the office doing the benefits for mentorship or interacting with your colleagues that these return to office policies are actually trying to get at.
Yeah, absolutely. So these are the practical things we're talking about: morale, attrition, recruiting. It's hard to recruit. And sometimes one of the huge benefits of this new era is you can recruit all over the country for the talent you need, but you give up something. But anyway, I digress. Let's talk about, we're lawyers here. We like to talk about litigation. Talk a little bit about we can do everything we can do to try to address the practical challenges, but what about the legal challenges? What's a good way to look at that?
Yeah, that's a great question. There have been several different types of litigation or potential litigation that we've identified as companies have returned to the office. One of them is with respect to reasonable accommodations. The question of, is it a reasonable accommodation for an employee to ask to work at home 100% of the time, even if the company is returning to the office? Another one has to do with discrimination and harassment. For example, could returning to the office cause a disparate impact against certain categories of employees? Another is wage and hour. Anytime someone's schedule or way they work is being impacted, you want to be thinking about the wage and hour impact. How is it going to impact their overtime, their ability to take meal and rest breaks, and issues like that? And then finally, expense reimbursements. This is an issue that became a real hot topic during the pandemic because employers really began to adjust in terms of compensating for expenses people had at home, internet bills, phone bills, things like that. And I think we're going to see that changing a little bit now that people are coming back to work.
All right. So that's a good way to frame this. We've got 4 kind of areas of litigation risk. Let's dive a little deeper into reasonable accommodations. I forgot to mention is we're principally talking about California law today, right? But there are some federal laws that apply. So in the reasonable accommodations, is that state and federal law, or what are we looking at?
We've taken a close look at the state and federal law to determine if there's a consistent answer that we can give to employers to help figure this out.
That would be nice.
That would be nice.
Consistent
yes.
would be nice. Yeah.
Unfortunately, as we look at the federal cases and the state cases, there's not yet a crystallized answer that employers can count on. So I think it's important or maybe helpful to dive into some of the cases that we've seen. And what it really boils down to is a case-by-case determination about if an employee is asking to work from home as an accommodation, does their work actually require them to be in the office, or can they actually perform it at home?
And this is accommodation for a disability, right? This is not an accommodation because I prefer to work close to my cat. I mean, maybe I have a therapy cat, so maybe that's not even a good example. But the specific accommodation is to an actual disability, right?
Yes, it would have to be related to a covered disability. And in California, that is quite broadly defined. Like you mentioned with the cat example, typically it would need to be something related to either a physical disability or even a mental disability, extreme anxiety or something like that. I think the challenge is, we talked a little bit before about when people went into the pandemic, the adjustments that they made. And some of these companies made grand statements about how we've figured out that everyone works just as efficient at home and they can use Zoom and they can use email to do their job just like they would in the office. And some employers may be regretting those kinds of comments because now it helps employees to be able to show that they can perform their job just as well at home as they would in the office. So one thing that we've seen in the lawsuits is a need to actually dig down and for the employer to emphasize, here are the very concrete reasons why we need people to be in the office. And the ideas of needing to be in the office for mentorship or just being around employees likely isn't enough to meet that standard.
Interesting. Yeah. So the takeaway there is it's very fact specific, right?
It's very fact specific.
But it can change over time, right? I mean, one could imagine that an employer in one context or era might have different job descriptions for positions. But, once you're actually facing a claim and a potential litigation, it's a little late to try to refine those things, right? So this might be something to look at around the corner, as we often say.
Exactly. The way that'll look in the documentation if you're faced with litigation is that the court or the opposing counsel would likely look at what the job description says. And if it says, you need to be in the office 3 days a week in order to make widgets, then that presumably couldn't happen at home because you actually need to be with the supplies and you need to put things on the conveyor belt, etc. It's a little bit harder for office jobs. I do a lot of my work on the computer. I'm constantly in Word writing things like that. It might be harder to argue that I couldn't do my job at home, even though I'm in the office now. I like being in the office and I like working with my colleagues. But you can imagine that, it's a harder justification to make that it's really required for someone who's basically on their computer all day. That said, we have seen some cases where the courts have come down and said, it is important. There's one example of someone who basically had a front office job and they asked to have a work from home accommodation in order to accommodate their foot injury. And this is a case out of California. The court actually found that even though this person had mostly an office job, they didn't establish that they didn't need to be in the office around people in order to do that. They said the idea they could have done it from home wasn't persuasive. We've seen cases come out the other way as well, which is why it just really comes down to a fact-based analysis.
All right, so let's shift a little bit to the second area of litigation risk, discrimination and harassment. That's a really hot area. A lot of concern there in the nonprofit world. I'm sure with every employer, but especially the nonprofit world.
This has shifted a little bit as we've gotten further away from COVID. You'll probably recall that early during the pandemic, the focus in discrimination cases in this field was about, are we treating people who are unvaccinated similar to how we're treating people who are vaccinated? Or how about people who wear masks versus people who decide not to wear masks? We've shifted a little bit away from that. And it's now more about, do people who work from home have the same promotion paths or career prospects as people who come to the office? You can imagine that if people are working from home due to a covered disability and an accommodation they have, if they're not getting those same opportunities, there could be a discrimination argument that they would have. Now, the federal courts have taken a pretty employer-friendly response. The plaintiff in that case had said that the company's return to office policy had a disparate impact against disabled employees. And the court basically didn't buy that. It said that argument basically assumed that all people with disabilities needed to work from home, which they said isn't necessarily the case. Across the country, there are people who have disabilities who are able to come to the office.
They may actually want to come to the office.
Exactly.
Yeah.
The basically one-size-fits-all solution that the plaintiff had suggested there, the court found was basically too broad.
Interesting. Wage and hour. This is an area that's interesting to me. I haven't really thought about it that much, but now that I see it on the agenda today, talk a little bit about how wage and hour rules are different depending on whether you're required to work from home or required to work in the office or a little bit of each.
I think the answer is kind of counterintuitively that the wage and hour rules are not different. They are the same whether you're working from home or whether you're working in the office. The challenge is, how are you tracking the hours that people are working? How are you tracking that they're actually taking their meal and rest breaks when they say that they are? And so, most companies, they figured out a way to do this during the pandemic, and it has generally worked. Now, as people come back to the office, traditionally, we view that as an easier mechanism to track when people are working and to make sure they're taking their breaks. But anytime you switch up an employee's schedule like this, it can lead to challenges. And so, employees may start saying, I actually should be compensated for part of my commute. For example, if they're on the bus and if they're If they're taking phone calls while on the bus, should they be compensated for that time? They'd have an argument that they should. The key is to really dig down on these facts and to figure out what are the boundaries that you're going to be setting? What is the guidance that you're going to be giving to your employees and the managers to figure out when they should be working, when they need express approval to be working overtime, and how to strike that balance.
Yeah, that is tricky. As you alluded in the opening remarks, expense reimbursements, how is that shifting as we go back to the office?
Yeah, so you may recall that during the pandemic, there was sort of an overreaction by the courts to everyone working at home. It seems like each court decision tended to give employees more and more rights to expense what they were doing at home. There was, employers were covering the cost of internet, the cost of phone. Most employers are still doing that for employees who work from home, and they should continue doing that. But there was some discussion about, do employers need to cover some of the cost of the mortgage or the water bill? And that has sort of fallen off of what's been expected. And from what I've seen, it's no longer on the horizon. Yet it is still important to be aware of where are you reimbursing people for time they're spending at home. If they have a hybrid environment, are you still giving them a tech allowance? Are you still covering $50 a month of their internet or their cell phone? It's a good idea to cover some of that, but employers will be deciding where they're going to be drawing the line. And it's important to note that, courts are not finding that employers have no obligation to do this, even when people are coming into the office. Courts are finding that if they're working at home at all, the employer likely still has an obligation to cover some of those home expenses.
Interesting. So those are areas where litigation might, some general topic areas for litigation risk. What about the local laws? In California, we're somewhat used to this. Other jurisdictions, it might not be as common, but talk about some hot topics in local California communities that are relevant to the work from home.
Yeah, one issue I'm keeping a close eye on is several localities within California who have imposed laws basically guaranteeing the right to a consistent work schedule. San Francisco has the family-friendly workplace ordinance. Berkeley, California has the Fair Work Week ordinance, and Los Angeles has a similar law. All three are pretty similar, but in general, the idea is that employees have the right to request either a consistent work schedule or a flexible work schedule to assist with their caregiving responsibilities. And the idea there, it makes logical sense, is that if you have a family, say you have young children, you need to be able to count on your schedule so that you can pick kids up from school, make it to doctor's appointments and things like that. And so in the absence of state or federal laws protecting that, we're seeing some localities, those notably on the liberal side of things, stepping in and saying we're going to guarantee that right for workers within our cities.
Yeah, and that reminds me a note to employers that have employees in multiple jurisdictions. Suppose our nonprofit has employees in San Francisco, Berkeley, and LA. Okay, those aren't so different. But then they also have a few in maybe Austin, Texas, and Kansas City, and somewhere in Georgia, and somewhere in New York. How do you advise those employers? Does everybody get what their local home environment provides, or do you give everybody the same benefit and spend more money as an employer?
I've seen employers do it both ways. I've seen some decide that they're just going to take a consistent line and say whatever the law in your jurisdiction is going to apply. What I've seen more often, particularly for nonprofit organizations, is to say we're going to apply the most generous policy across our workforce. And the reason for that is twofold. One of them is all employees talk. Regardless of where they are, they're going to talk on Slack, they're going to talk on Teams, whatever it is. Everyone's going to know what rules apply in each state. And it just is a negative employee experience if someone in California is getting a more flexible, consistent work schedule than someone in Texas or wherever it is. And then the second reason is just practical. It's easier to administer a policy if it applies generally across the organization. Bottom line, even if it costs the company a little bit more, it is considered better among the people implementing the policy and better among the employee base to have a policy that applies across the board.
Yeah, that totally makes sense. And that's a great segue into our last section here, which is best practices. Given all of the litigation risks and the practical risks and challenges, can you highlight, as to kind of summarize for our listeners, how do they go about thinking of best practices to go and check their policies against and their practices?
Yeah. So if you don't already have a return to office policy and you are asking people to come into the office, it's a good idea to start drafting one. And the reason for that is that it's just so helpful to ensure that the rules are being applied consistently. Oftentimes, one of the main drivers of litigation is when things are not happening consistently among employees. So employees might start to wonder, oh, why is that person getting this benefit and this other person is not? And so if you get that all in a policy that it's easy for managers to consistently apply, that can help significantly. It also goes back to where we started this discussion about the balance between ensuring efficient work and employee well-being. Sitting down and putting together a policy that addresses that can help to make sure you have all the cross-functional partners that you need in a room to figure out where that balance is and how to get it down into a written policy. And then finally, I think it's important to mention safety. If you're asking employees to come to the office, you want them to be safe when they're in the office. So employers should be reminded that there are pre-existing laws about an injury and illness prevention policy, more recently a workplace violence prevention plan. Some additional considerations to keep in mind that, if employees don't have policies addressing those things, they could include them in a return to office policy or use it as a jumping off point to develop them.
Yeah, good point. This is a good opportunity to kind of clean things up a little bit and bring things current. We have a recent webinar from the firm, right? What were the topics covered there? And I think we'll put that in the show notes so it's easy for listeners to find that.
Absolutely. So recently at Farella Symposium, we covered this topic, returning to the office. We also covered recent developments in the Equal Pay Act and also generally new laws in California that all employers should be aware of. It's definitely worth some time taking a look at those.
Yeah, that's great. And that is a webinar that I believe is on our YouTube channel. And so interested listeners can get that from the show notes. So thanks so much for joining me today, Ben. I think this had a lot of really good content and will be very welcome by a number of employers, certainly in California and probably in other areas of the country as well.
Thanks so much, Cynthia.
So that's all for this episode. Be sure to check out the show notes for links to more resources and for our organized playlists on this and other related charitable topics. The Farella YouTube channel has playlists for all of our charity resources. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.